Your Lordship.
Huh?
Mr. Your Lordship,
I just forgot. Let me.
at the end of pending the charges.
Oh, yes, this is that man.
Can
Yes,
it be interpreted by this other court?
sure. That's the only thing I
Only
wanted.
thing, my lord.
What, under what
Before
circumstances
going to the law,
we
my
can?
lord, Before
Huh?
going to the law, I will recently take the tax subjects.
Not necessary.
My lord, here only.
Article of charges,
Few
the
lines
article of
added.
charges are very clear.
No, I will take my lord in the facts and circumstances case, the judgments which I have, these judgments I have brought my lord. Only-
Show us, give us.
Well, only one fact, my lord, only facts only two to 5 lines, my lord. Right.
Yes.
My lord, met for the post of constable of CISF. I made an application. I have given
That was in
the certificate, caste certificate,
OBC and CBC.
caste certificate in the year 1996. Well, that conduct by card, case number is there from the Tahsil Almani. That was produced along with the application. I was selected, I was given an appointment as the general secretary. My lord, in the year 2015, my lord, they have stated that made query that conduct whether it comes on SCBC or OBC, my lord. In Odisha, it is OBC also. That the law is there. Then, my lord, the Tahsildar confirmed that the certificate which was granted by in 2015 is the genuine one. Now, after my lord 15 to 9, now the 2024, they have framed the charges, my lord, and framing the charge under 36 of CISF rules, my lord. I'm only taking to the two CISF rules to your lordship. Then I'll go to the judgment file. Your lordship, I come to rule 36. Central Industrial Security Force Rules 2001. And same certificate, I also produced another certificate Tahsildar granted. I produced it. They said in the 2016 that you give a certificate of Tahsildar, you are OBC. The Tahsildar did not grant it. Only 36 your lordship.
Rules or act, what you are referring?
Rule, my lord.
Rules of 2001.
Rule 36, procedure for imposing major penalty. My lord, product same books. Rule also told you.
Rule 36.
Rule 36.
Yes, sir.
Rule 3, your lordship kindly suppose. Where it is proper to hold an inquiry against an enrolled member of the force under this rule, the disciplinary authority shall draw or cause to be drawn up the substance of the imputation of misconduct or misbehavior into the definite and distinct articles charges. The statement of the imputation of misconduct or misbehavior in support of each article of charges which shall contain a statement all relevant facts, including any additional confession made by enrolled members support. My lord, B, a list of documents by which a list of witnesses by whom the article of charges are proposed to be sustained, my lord. This is important, my lord. I am taking to that B. Your lordship can come to the charges what they have framed. My lord, brief appeal brief page 57, my lord. '56 is the memorandum of charges, and 57, no witnesses, no document on which they rely on. Now, I challenge this framing of charge 2 grounds that in the 1996 I produced the document. You gave me the appointment, and in the 2025 you made a dispute whether that is SCBC certificate which I produced, that whether it comes on BC. Thereafter, you did not frame the charges. I am at the fag end of service. I completed 28 years service. Now, after 9 years, you have framed the charges against me, myself, without giving me the supporting document to witness them to be proved mine. My humble submission is twofold, my lord. The delay in paying the charges from 1996 to 2020, but they may take a ground that delay is caused that it was not detected, my lord. It was probably detected, you detected 2015, my lord. You wrote to me, I produced again on the same certificate, my lord, from the Tahsildar. 9 years took the paying the charges. That delay in paying the charges is the ground to partial charge sheet, memorandum of charges. Second, my lord, that the charge you have framed, the charge sheet, does not contain the as per rule that name of the witnesses and documents on which you base to prove the charges. I rely on the judgment of first minor 1990 supplementary Supreme Court 27738. State of Madhya Pradesh and Bani Singh. Para 8. Para 7 like that.
Para?
7, from 7 to 9, small. Of the learned counsel, the appellant contend that even the tribunal was right in view of it should have remanded the matter to fresh constitution by the screening committee and tribunal. And tribunal should have not have given the retrospective promotion to him of the selection. But in case the learned counsel contend the tribunal itself upheld remarks of the year, para 4, man, not 7, para 4.
Para?
4. The appeal against the order dated December 15, 1987 has been filed on the ground that the tribunal should not have passed the proceeding merely on the ground of delay of logic and should have allowed the inquiry to go on to decide the matter on merits. We are unable to agree with this contention of the counsel. The irregularities which were subject matter of the inquiry is to have taken place in between the year 1975-77. It is not the case of the department that were not aware of the said irregularities in any, if any, and came to know it only in 1987. According to whom, even in April 1997, there were doubts about the involvement of the official in the said irregularities, and the investigations were going on since then. If that is so, it is unreasonable to think that they would have taken more than 12 years to initiate a dismissal proceeding as stated by the tribunal. There is no satisfactory explanation for the inordinate delay in issuing the JAP memo, and we are also reviewed that it will be unfair to permit the departmental inquiry to be proceeded at this stage. In any case, to interfere with the tribunal's order accordingly dismissed. Then, my lord, another decision I rely on 1998 4 SCC 154 State of AP and Radhakrishnan. Para 7, my lord. The same verdict down has been successfully raised.
Yes, sir. Second judgment?
Second minor judgment, the 1998 volume 4 SCC
Yes.
1541. Para 15, 16, 17. Placing. It would therefore appear that the charges have been framed against the respondent merely on the basis of reported 7,
Paragraph
15. It would therefore appear that charges have been framed against the respondent merely on the basis of the report dated 7/11/1987 from the Director General Anti-Corruption Bureau, which is the general nature raising the accusing fingers on the various officers of the corruption, but without any reference to the relevant files and pinpointing if the respondent or any other officials charged was at all considered as the added evidence of unauthorized construction in the multi-story complex. It was not necessary for us to refer to the charges issued by memo on 27/10/1995 and on 1/6/1996, and that would not be subject matter for questioning either the tribunal or before us. On the other ground, which the tribunal was the memo dated 31/7/1995 issued under the 1992 was the of the 1991 rules. Inquiry proceeding initiated on the 1963 rules would be continued even after coming into force in 1990 rule. It is correct that the inquiry proceeding did progress after issuance of one so on the extent of the inquiry officer was appointed that should have been concluded in the 1996. If the memo of charges had been served for the first time in 1991, there would have been no difficulty. However, the present case it would be only irregularity and an illegality vitiating the inquiry proceeding in as much as the inquiry officers was appointed by the there had not been any progress if the base memo is issued or the charges against the delinquent officer
That is what I'm saying.
at any prejudice has been caused to him. He can always challenge the second memo rather even not first on the ground, one of the ground of delay, which he did. Only delay ground they are challenging here. That was past my lord. A last judgment, my lord, which relied on both the two judgments, my lord. That is, PV Maharan on the Memdi Tamil Nadu, my lord. If judgments have been relied on in these judgments, my lord. What is kind of paragraphs? That the very same ground has been specifically raised in this appeal before this court.
Which paragraph?
Paragraph 7 at page 640. The very same ground has been specifically raised in the appeal before the court, wherein it is stated that the delay of more than 10 years in initiating a disciplinary proceeding by issuing a charge memo would render the department vitiated, that in absence of any explanation for the inherent delay in initiating such proceeding, of issuance of charge memo would justify the prayer for quashing the proceeding as made in the year, my lord, 9 years, my lord. They dictated in 2015, my lord. And initially, I promised that they have verified it and that is genuine in 2000, in the year 1996, my lord. And during my long 28 years career, I have no, my lord, I have not did any mistake or misconduct anything during this discipline service, my lord. Now, after 9, I am going to retire very soon, my lord. Now you have initiated disciplinary proceeding. And my lord, your lordship kindly and promise one thing, my lord, whether SCBC is the OBC or not, my lord. Am I taking to your lordship's? So the Odisha Reservation Force of Service of Social and Educational Backward Classes Act 2008, my lord. They said that this SCBC is your my lord. Your lordship can come to rule 3, rule 2 of that rule. Odisha reservations of particular lordship kind class of this. I am giving 2 rules. Volume 15, page 844. 844.
There is an improved order.
If an order is annexed to 1. At the stage of admission, it was dismissed on the ground.
No, action one is.
Paragraph 7.
Where is the judgment? Which judgment you are? You are challenging which judgment?
Order, my lord, that is Annex 1 at page 12 of the brief, my lord.
No, I do not find that. That is what I'm saying. Oh,
Yesterday, your office has gone to
no, yes.
Paragraph
Yes.
7.
No.
At page 12, my lord.
Yes, no, yes.
Normally, your office can come to 2008 rules. Orissa reservations of post or services for socially educational backward classes Act 2008. Your office can come to rule 2E. Social and educational backward class means backward classes are defined in clause.
Whatever you are arguing, we appreciate. Sorry to interrupt. Our endeavor or our query was not this. You may have a very valid defense. You may sustain your stand. But what stage you can challenge? The question was that when an article of charges are submitted or served upon you, you have come for quashing of the article of charges. Now the law have to be understood what stage and what should be the endeavor of the court at such stage when simply an article of charges is served on you, whether the court will enter into the merit and find out whether the article of charges is factually sustainable or not. Can the court go into that aspect? Prejudging an issue, authority has not decided as yet. Authorities will take a conscious decision on the basis of an evidence. This is what yesterday I posed a question that there are several stages of the disciplinary proceedings. This is what is the first stage.
Yes.
What should be the endeavor of the court and what should the court do in such type of cases? Say the show cause notice is challenged. Article of charges, like a show cause notice, is challenged. To what extent the court may enter?
You
have cited a judgment, I will definitely deal with it. There, so at what stage they moved? Actually, a judgment has to be understood in a context in which it is so made. We have to understand that. So what should be the stage of interference by the writ court?
That in banishing case,
we have seen so, and I think I am very much indebted to my brother in all respect.
Okay.
Whenever I say something, he always goes and find out this judgment is still holding the good law in the field, or has been overruled, or has been distinguished. My brother has come up with all these foods he has come up.
I have exercised my knowledge.
My brother has exercised more sitting here. I've seen all these judgments. in a subsequent judgment has already been.
That is, I know, my lord, one another.
When you know, then why you do not cite?
My lord, that is state of Orissa or some other cases. That
No, sir. There is another judgment of the Supreme Court. What is the name? Ajay Kumar Chaudhary's case. 2015, much after those judgments.
But these judgments, I don't know whether. But in some
Ajay Kumar Chaudhary, I am saying, these judgments of the Supreme Court, these are taken into consideration.
The latest one.
Yeah,
And this
only
is-
my lord, on the ground of delay, my lord, I have.
And that too is the 3-judge bench decision.
Still
It is a Achilles Jha.
Yes, delay in this finalizing the decision that it's so back to law. Once inquiry is conducted, the opportunity is given. Three judges.
So if there are 2 judges bench and a 3 judges bench, then which will the High Court follow?
That is judgments. That I can say, my lord, is still not followed. My lord, here, my lord, they
We
have.
have seen, sir, go file your reply. We are extending the time to file reply.
My lord, now they have, my lord, already giving the notice on the proper furniture to file my show cause, my lord.
So you go and file your so cause.
My lord, your lordship, I pray, my lord, that let them serve the entire charge sheet along with that.
Sir, I have seen, if you want, I can tell you everything is there. Everything. Your client is either too, very mild word, very intelligent, have also kept you in dark.
Your lordship, I give me an opportunity, my lord.
You can file reply.
The written statement of defense, my lord.
That is what I'm saying, reply.
Yes, the defense shall start the proceeding from the beginning.
The repetition challenging the article of charges challenge it, whatever you go there, we'll consider thereafter.
Item number 3.
Yes, sir. Still continuing to argue this point. On the last occasion, you said, let me ponder upon whether it is still alive or it is
I had taken instruction that's still alive.
still alive.
If the Lordship would kindly.
So can we fix after the vacation? Because this before vacation, will it be proper?
It's up to you, Lordship.
Is after vacation, let us fix. Whether unnecessarily hearing of this, because we have to answer the reference.
I say Lordship, please.
Third week.
15th.
15.
15th January.
Get the record.
Yeah, but only that.
Try to get the record.
Yeah, but only record can save me or save him.
Item number 4.
He has 2 points.
Yeah, but
Yes, sir.
only on that technical point. I can
No. Second point. Second point.
say second point.
The collector
In the-
of Bhadra decided to open a on acres out.
Collector cannot decide to. How the collector? It is a excise department who will take care of.
I have made a representation that is under Annexure 7.
What?
There was an inquiry in the front of Annexure 3, page 28.
Uh,
There is an inquiry. In the inquiry, it is found that there are school and temples also there. The inquiry should submit a report. Page 20, 28, 29, 30. And after that, report, nothing has, collector has not taken any final decision also. Below the page 29, the inquiry report, paragraph number 4, first last. It is ascertained by the inspector excise that the temple is not coming under definition of worship, place under section.
What is the temple is not coming under the place of is not a place of worship?
Yes, Mr.
What is said?
That is the report of the inspector.
Is improper, cannot be considered. A temple is a place to worship,
Miller.
is known to everybody.
Miller.
It's a place of worship. How can this, who is this authority?
No, there is a definition in the excise rules which defines, my lord may kindly see. There is a definition.
What? That it is not a place of worship.
I'm placing.
And further it is written,
But,
only
the
8 to 10
place of
persons are
worship-
coming there.
Place of worship has been defined in the rules. Means any public place where more than 20 persons congregate in a
Sir,
public.
how do you know? Congregate all the time.
Miller, that is-
There may be a timing. At the timing, there may be 1,000 persons, there will be 200 persons. And every time at the interval, 1%, 2% comes and worships and goes.
No, but that is.
Not at a time, the 20%. It has to be.
This is what the statute provides.
No, sir. No. It's a misrepresentation of. There should not be a conglomeration of 20 at all the time.
Yes, my lord, but the statute provides. my lord,
No, sir.
definition.
No, sir.
My lord, on the basis of.
It has to be tested on that score. Cannot be done. What are you talking about?
What I'm saying, Lord, is that the statute provides a definition, and as per this definition is given a factual report that there is congregation of less than the required number of said number of persons.
How do you ascertain? At one point of time, there may be more than 20. At one point of time, it will be less than 20. How can you one say that it is a conglomeration? And you say that every time there should be a conglomeration of 20. It's farcical approach.
Yes, my lord, that report may be wrong. I'm not objecting to that. my lord. What I'm
I
saying,
don't believe
the
it.
basis of the report is this
No,
rule. with-
can't.
Whether the.
Now, what do you want?
The collector have not taken any action on that.
You take a action and then, brother. I'm very bad in. This is a case they have to take.
Item number 5.
This is a matter wherein I'm arguing that inaction on the part of the opposite parties, the income tax authorities, wherein my appeal effect order has not been given effect to. As in, appeal effect order, as in
Appeal effect order, I do not know.
there is.
The effect of the appellate order has not been given.
Yes, there also there was an assessment order wherein there certain demand was raised. I challenged that order before the CIT appeals, and that came in my favor. After that, the AO has passed an order giving effect to that appeal. However, that refund, which was supposed to be granted to me along with interest, has not been given. In some matters, it has been allowed partially. In some, it has not been allowed. However, there is no reconciliation. We have given representations also, but there is no response to that.
Yes, my lord, they have a genuine refund, my lord, from 2009.
So why you are not paying?
We are in process. Some refund has been already taken.
Pay within, we are directing you to pay within 4 weeks.
If, well,
Along
Along with the interest, that is inevitable, sir. How much is the statutory interest you pay?
well, we are rectifying certain orders. We are rectifying certain refund orders on basis of the adjustment of the subsequent and years. And we are in process of that. And we have got the, status of the refund status.
But what would happen to an interest component which you have unreasonably, suppose the refund pertains to 2002. Now you are trying to adjust this for on the computation in 2025. What will happen?
Yes, madam, we are
You have to pay an interest till that.
On which amount?
Initial 2002 amount.
Well, we are in the company. We are computing that.
From 2002, the interest calculate,
Demand has been.
whatever, if you want to adjust, then adjust for a present liability.
Right.
Up to the date of adjustment, you'll have to pay the interest.
Right.
Yes.
I have obtained the status
Well,
from the department.
Yes. Give it one copy to him. You have got, that's all. Yes, direct them to process, complete the
We also
process by
find
4 weeks.
So got it. Finished.
Process by 4 weeks. All such matters.
yes,
All the
item 8 also.
Tag here.
This is connected for the same SSC. So, right,
Which one?
item 8.
Same refund.
Same refund
This
issue.
five,
You are in 8, who is there? You?
Sorry.
no,
Do it.
five which are tagged together.
All are same.
That is covered by this
Yes, yes.
table.
Yes, it's a different period.
No, that is also same, but that in
7, same.
Eight
Item,
we have already.
item number 9.
reassessment notice, you have to without following of assessment procedures. Reassessment notice on the principal manipulate of that without adding the mandatory assessment.
This is our done.
Pending,
The pending one.
pending one.
Yes. Last line.
Yes.
Hmm.
Item number 10.
May I please? Petitioner, my lord, is a petitioner is a lessee of mine, my lord. And as per the minerals extracted, he pays royalty as per the determination of the Indian Bureau of Mines. And accordingly, my lord, he pays GST on royalty on that amount. And a regular audit was conducted under 65 of the Act. Subsequently, my lord, the CAG, my lord, they, my lord, initiated the audit. And strangely, the lordship would kindly come to, my lord, the annexure 6 at page 82. The relevant portion of what they did, my lord, is they said that your royalty amount and the GST payable would be from your books of account, the sale figures from your books of accounts, from the profit and loss account. Thereby, my lord, the royalty will be determined and you pay this amount of royalty. And since you have paid the royalty on the IBM rate and this particular rate, there's a difference and you pay that balance amount, not as per the show cause. My humble contention, Lord, as per the MMRD Act, your lordships are aware that there's a provision of Section 9 dealing with royalty of the average sale value. This average sale value, my lord, is determined by the IBM. And every 42 days prior to the filing of the returns, this rate is fixed. So, my lord, this is a statutorily fixed rate. And my profit and loss account may vary, my lord, according to various market conditions. And while determining this, my lord, actual sale price, the IBM takes into consideration many of things which is, my lord, codified under Rule 42. No. Your lordship, kind consideration, your lordship may kindly take this.
Take a defense, go there.
Sorry, no?
Go there and take a defense.
So this is prima facie, my lord, illegal, my lord. Because they, my lord, I had taken defense. If your lordship would see, my lord, I have given the table, my lord, before them. They ignore it, my lord. If your lordship may kindly come to
Ignore and then pass the order.
No,
No.
they have given me a show call.
call.
Please, after your lordship may see, before the audit authorities at Annexure 7, I have, my lord, specifically said, if your lordship would kindly turn to page 92, my lord. Page 92, my lord, Annexure 7 begins at page 89. I've given a reply, my lord. They do not consider it, my lord, and if your lordship will kindly turn to page 92, paragraph 3, my lord. The taxpayer respectfully submits that the audit observation report, which is enclosed in the imbued letter, includes a chart which explicitly states that the senior audit officer, Office of the Principal Director of Audit Central Bhubaneswar, has determined the GST amount payable by the taxpayer basing on the amount of royalty not paid. This determination was made by considering the sale value of the Indian Bureau of Mines revenue, Bureau of Mines revenue from operations as per the profit and loss account, and by calculating the royalty amount based on the revenue earned from operations as per the profit and loss account. The SAO appears to have adjusted this amount against the royalty already paid as per the annual returns filed with the IBM, ultimately ascertaining royalty not paid and the corresponding GST liability on the amount. The chart provided in the audit observation reference.
This is post taxable event.
Months. And your lordship would appreciate that the normal audit under 65, they accepted it. The CAG comes
Taxable event occurs at the point of
at the point,
releasing and
at the point of extraction, I pay that amount, and my lord, all my returns with the statutory authorities or the mining department have been accepted. My lord. If your lordship would see, I've already also and then the returns, my lord, and the returns have been accepted. And interestingly, my lord, the CAG in their own circular, if your lordship would see, would kindly turn to Annexure 10 at page 336, my lord. And if your lordship would come to page 343, my lord. They also say, my lord, that the IBM is the rate, my lord. At 343, the lordship would see para 3.1. Lordship got it? It's a report prepared exclusively for the state of Orissa, my lord. Mineral ores occur with variations in chemical and physiological properties. In the case of iron ore, the ores can be categorized based on percentage minerals, different grades, so and so, so and so. As per Rule 45 of MC RD rule, all mining leaseholders are required to submit monthly returns on production, dispatch, and sale of minerals from their lease area. The return should contain data on the X mine price and the various grades of lumps and fines dispatched from the mines. Then this is important now. These X mine prices are reported by the lessees, form the basis on which the average sale price are notified by the IBM for the various grades of iron ore lumps and fines. The royalty payable by the leaseholder on the various grades of iron ore lump and fines dispatched from the lease area is worked out as a fixed percentage of the notified average sale price for the respective grades. Thus, it is crucial for the state government to monitor X mine price, grades, and classification of iron ore as lumps, fines.
So according to them, there is this IBM, which is the authority to ascertain that what should be the
Average sale
quantification,
price.
what should be the average sale price, and what should be the royalty that has to be paid.
Money.
Then in that event, that is sacrosanct, and on the basis thereof, if the GST is paid, then
Then
they
there is no
cannot.
question.
on
And
the
if your
date of filing return,
Money.
these figures are available with me.
Money.
So
Money.
post sale or post transactions
True, money.
after filing return,
Money.
that cannot
Form the basis, money. And my profit and loss accounts are variables. depending on various conditions, my lords. But all the same, I pay, Lord, as per the determination of the IBM, my lords. As per the statute, also, if your lordship can take up the rules.
Something is at something.
I'm sorry.
Yes.
B. I'm sorry, thank you. If your lordship would see, my lords. May I just place, my lord, or your lordship may kindly see Rule 43 of the mineral other than atomic and hydrocarbon energy concession rules. Your lordship may kindly. Rule 43. The procedure for computation of average sale price is given in Rule 42. Then Rule 43. Publication of average sale price. Pages 415 of the book of professional notes. 415 notes. The Indian Bureau of Mines shall publish the average sale price of each mineral grade concentrate removed from the mining lease in a month in a scale within 45 days from the due date for filing of monthly returns as required under the Mineral Concession and Development. So this particular average sale price, as per taking into conditions of Rule 42, are determined by the IBM. And if your lordship would see the schedule of rates, my lord, the schedule, if your lordship would see, because Section 9 refers to a schedule, that is Schedule 2, my lord. Section 9 deals with royalty, payment of royalty. It refers to as prescribed in the schedule. The schedule is at page 36S. Schedule 2, my lords. Page 36S. And if your lordship would come to page 36U, see, if your lordship are holding this professional bear,
Yes, yes.
I report
36X.
Entry 24.
Entry 24, 36U, capital U.
15% of the average sale price.
And this average sale price is determined by the IBM as per Rule 43, following the procedure of Rule 42. And my returns are accepted by the mining authorities. Now they come up with a strange proposition that no, your books of accounts, whatever is the sale figure, therefrom we'll determine the royalty and therefore you'll pay this GST on that. And some crores, my lord, are now being given to me as a show cause. My lord, if the lordship will kindly turn to the
And
show cause.
visualize what I was saying, that it all depends upon the Fe content into a particular, ore. It may at times contain 60% of Fe, 70% of Fe, 40% of Fe. So the rates definitely vary according to the Fe content. Any ore which has say 80% of Fe will definitely attract the higher price than which contains a 30% or a 40% of Fe in it. So now the concept is that you have to just make a average sale price. Suppose hypothetically, if it is a 1 rupee a kilo and to 30%, and it is a 10 rupee a kilo for 80%, then the average has to be calculated on the basis of this, and it will come to 5.5. If we go by a simple mathematical precision.
And this particular
So the GST has to be attracted on the basis of 5.5.
It can't be on my books of
It cannot be on 1, cannot be on 10.
And the average sale price, my lord, as per the statute, is determined by the IBM. And this is, my lord, a variable.
I understand, but...
And your lordship would see, my lord, if your lordship would kindly turn to Annexure 11 at page 346, my lord. My entire, my lord, industry will come to a standstill, my lord. 37 crores, 31...
Why not on each sale on the basis of a price be determined?
I'm sorry, I couldn't get my lord.
Why not? On the each sale, on the basis of a price which you charge. Royalty cannot be termed as a tax.
No.
There is a distinction between a royalty and the tax.
True.
The royalty is not a tax.
No.
The taxable liability is something different.
True.
And if it is on a basis of an invoice or a sale price, then in that event, they have to work out on a basis of each sale.
But unfortunately, my lords, that
This is for the purpose of determining the royalty.
Man,
This rule 42 is completely different. Then one has to find a distinction between these two.
and once will also.
So you mean to say that this is demand come show cause notice. Prior to that, inquiry was conducted.
Prior to that, an audit.
This audit was
Audit.
conducted and the audit has.
In the audit, you gave a reply
Man,
that was not considered.
consider.
And this provision is invoked 74.
Man,
74, not 73.
not 73.
This is 74 is the fraudulent one. I understand.
So the
The
element.
distinction is evasion of the tax or evasion tainted with fraud. So it's a case of a fraudulent one. May have been a case of a 73 because of the ambiguity and some kind of a confusion which is created.
And your lordship may see the grounds. of
Brother,
show cause.
that I believe that needs to be pondered upon because the
Audited by the controller. CAG. Controller and auditor.
Oh,
Department
they have
CAG.
verified returns.
Sorry,
They have verified
They have
returns. It is not 63 audit.
65 was completed.
65.
65 was completed. Thereafter, the CAG comes in.
Acha, acha.
He picks up some information, ignores the IBM rate.
where is that judgment of the Constitution bench, judgment of 7 judge on the royalty?
9 judges.
9 or 7? 9.
India Cement and Keswara.
No, it was initially taken, if I correctly remember, by the then Chief Justice of India. He wrote, and there was one line which really creates a problem, which says that the royalty is a tax. And the 5 judge bench subsequently doubted it and clarified it. I think then it was later on referred to.
7 judges. Says on these two. Mineral area development.
I remember those incidents. One line in one paragraph was the main when it says that the royalty is the tax. That was the sentence which was used.
They took it as a printer's
Then the 5 judges, they clarified it that the judgment does not really say that the royalty is a tax.
So cess on. 2 words created all.
The lordship may see the basis of.
We can understand 74 to some extent.
Would
But
your lordship permit me for a second?
Lordship appreciate, my lord.
Lord, I am on
The
VC.
lord who has
Am I audible?
discharged his liability as per the statute.
Lord, am I audible? I am on VC.
who is appearing?
Lord, my lord, can I assist your lordships? This is Ashok Parij, I am on VC.
No, for what?
No, not for this case, only for MADA. MADA judgment is 2024 10 SEC page 1. 2024 10 SEC page 1. And your lordship is absolutely right, my lord. At paragraph 550.1, they say royalty is not a tax.
Yes, the royalty is not a tax. That
No, definitely it was. Actually, the parent judgment, there was some kind of a mistake.
yes, no.
Your
Where
lordship
it
is right.
says that the royalty is a tax. Then this was clarified that no, it's not. It never intended. There is a
Correct.
typographical or ministerial error that has cropped up. So
That was the stenographer's devil is what they called it.
My humble submission would be.
Lord, I am in some other matter. I just saw your lordship asking the question. I thought I'll assist you.
This is what I feel that the ascertainment of a sale, average sale price for the purpose of imposing the royalty is one separate and distinct incident than the imposition of the GST on a sale price.
That means, my lord, the taxable figure, my lord, could change, my lord.
Obviously,
No, because
sir, what is the rule 42, what it talks about? That because of the, these peculiar facts and the phenomenon, peculiar facts and a phenomenon, it will be very difficult to ascertain a royalty in a uniform manner. So what it says is that the IBM will be the authority who will go and will ascertain the average sale price.
And it is done every 45 days, my lord.
Oh, I understand. The average sale price. So that a uniformity in imposition or a liability of a royalty can be ascertained or can be ensured. It is only for the purpose of the royalty, because very difficult then a ore containing 30% of Fe and an ore containing 80% of Fe. So they wanted to do it that we will give you a buffer every time. It's a very humongous and hilarious task to find out every time that what the Fe contents are. So we are just taking it as an average and then putting you that you'll have to pay. It may be more in case of a less Fe content. It may be less in case of a more Fe content. So in order to have it a uniform one, they have done it. But that does not mean that so far as the tax liability is concerned, the GST, whether the same principles will apply. I have you satisfy me. You satisfy me, and
I'll satisfy you. Because
and my brother will always assist me, no doubt about
Lordship
it.
would appreciate the domestic sales which occur as also taken, my lord, by the IBM as per 42. So what your lordships have rightly said,
IBM is for the purpose of royalty.
my lord, and this is GST on royalty, my lord. They can't come.
That is what is there. That GST on royalty on what basis?
GST on royalty is the basis, my lord, which is statutory.
Is it a GST on a sale price? You have said that sale price, profit and loss, everything you have taken.
It is the profit and loss account which has been taken.
I understood, sir.
That will differ. That will differ, my lord, on the various market conditions, my lord. I pay, my lord, if you say,
sir,
that means there will be a starting sale.
Sir, if the market, if there is a recession in the market, that the price of a high volume of Fe content ore, which was there, say 45 days or one month before, may not be same in the another month. It depends upon a demand and the supply.
That's why it is revised every 42 days, my lord. And
That's why I'm saying, so it may vary. So they have taken into account your profit and loss account.
That can't be, my lord, a measure of tax, my lord. Once they say that I am imposing GST
and also on a sale invoice.
Yes, my lord. Actually, in fact, it is come to our knowledge from the CAG report only. So suppression is also there.
Suppression is never there, sir. This is what there is a confusion. You can't say with clarity because the different laws are there, and he is correct in taking a stand that once a particular authority have adopted a mechanism or modalities, then every authority must adhere to that modalities and mechanism. So you can't say that it is a fraudulent intention. It's merely an interpretation and an applicability.
And
I have reservation on 74. I can't say anything on that. Strong reservation on 74. But I am more on a broader aspect, whether these principles will apply to a GST as well.
Also,
then 65, your authorities have accepted the returns. So returns, it is according to his books of account.
What is your uniform standard? Everywhere in all the cases, are you taking a same stand? Or you have chosen one and wanted to have a test case?
Then I have to take instruction. But similar cases, my lord, 2 cases I have received copies, my lord, in which, my lord, this proceeding has been initiated on the basis of their profit and loss account and on the basis of the...
Then more to come.
Yes, my CAG report, my lord.
And the sale invoice.
My lord, sale invoice. And ultimately, the tax liability depends on that sale invoice, my lord. And it is a so-called
No. Taxable event on royalty.
on royalty.
What is?
That the taxable event.
I said tax on royalty. You are charging tax on royalty.
Right, my lord.
When is royalty paid? That is the taxable event.
You are not charging on a sale price.
That is a separate one.
That is
That is separate one.
Oh, this is royalty.
Royalty. No.
Oh, I just thought everything is.
No,
That is taxable event.
Oh.
I said,
It's not a taxable
on the beginning,
event.
that's why I said, what is the taxable event?
No. Thank
And
you.
what would be the measure of that?
Thank you. Yes.
And my lord, this is so-called, my lord. This is so-called, my lord. That is
Apparent.
So 74 you have to
74, my lord. There is material for initiation of 74, my lord.
examine.
Is, and it requires a factual.
Let us see a particular plea or a taxable event has been declared by the Supreme Court to be bad. And you continue issuing a so-called notice, taking it as a taxable event. You will say that it is a show-cause stay, so court should stay away.
I will not. Definitely, I will not.
So if on the basis of, not on the fact, but on the basis of the law, it appears to be infirm, then it's a pure question of law.
Now two things you have to satisfy. That what is the taxable event for levying GST on royalty? Number one. Number two, the measure of tax. Of course, that is royalty. Then 74, initiation of proceeding under 74 based on CAG report. What is your stand on that? You must have formed an opinion. Prima facie.
It is not a voluntary act. There is a distinction. If it is a voluntary act, you can definitely, like in an income tax, you have incorporated even a sale of a property, immobile property, fetching a value which is shown in as a consideration price. But the circle price is higher, so the differential amount would be taken as an income for that year, and a notional income for the purpose of imposition of the tax. I can understand because that's a voluntary act. But here it is absolutely an involuntary act. They have to pay the royalty as per the modalities provided in the statute itself. They cannot pay less, they cannot pay more. If it is a fixed one, can you say that no, I do not know, I will go with the higher one? Under what authority? I do not know. How can you do it? I was under the impression that it is on the basis of a sale price, so I was just thinking about it, that how can he sustain it?
That is a different input.
But if it is only on the royalty, then in that event, though, whatever actually he has paid not to the private individual or a private player, he is paying to the government. The royalty is charged by the government. How can there be an under-dealing, or how can there be something else? Unexpected. I have.
The word appears.
I
74.
have. No, sir. It needs. Brother, it needs. It needs a thorough examination. Maybe a show cause, but the foundation is weak. Shambles. What to do? Brother, I need.
This is an interim application. There is an interim application.
Yes.
Sir, we are in the process of a consultation.
I'm sorry.
And a deep consultation.
I'm sorry. I'm sorry for the interference.
File some reply.
Give a reply.
Item 11.
3 weeks after the reopening reply, the counter. 1 week thereafter the reply. In the first week of May. Sorry, February.
Yes.
Reply.
Item number 11.
Oh, I was under the different impression.
Yes.
11.
Your Lordship, wait, please. Your Lordship, I am an individual, Your Lordship. I filed my return. There was a 148 notice issued, then which culminated into an assessment proceedings. I participated. A demand of 30 lakhs approximately was raised against me. The same I have challenged before the NFAC appeal. It is pending, Your Lordships. The date of filing of appeal is 21st April 2022. Till today, Your Lordship, the pleadings are complete. Everything is complete. They are not deciding my appeal. Refunded
And
adjusted my refunds of more than 60%.
Adjustment or refund.
60% refund has been
You
adjusted.
can't have a bird in hand and two bird in the bush together.
And Lordships are aware of section 256A. Capital.
You can't.
A limited
Or
grievance.
have a cake and eat it too. Either you dispose of, dismiss, modify, whatever. But you can't, you can't reap your own wrongs. Sir. And there is no accountability.
Pleadings are complete since December
Is
20.
there any mandate that if you do not dispose of, you have to provide a reason?
Right.
Is there anything? From the government side?
No.
Dispose of how soon?
Within 3 months. 3 months, right?
All this while what they will do, I've just filed my return for this financial year. They will again adjust the refund.
Yeah. Ultimately, your appeal fails their voice.
So let them, there is no difficulty.
Dispose of within 2 months. Or 3 months.
Obliged.
Item 12.
From the detail of the moment.
Item number 12.
Is equal.
12.
Even though multiple years is one of the issues. There's additional.
Galvanizing unit. Yes.
No, it's galvan of the name. It's not a galvanizing unit. The name is.
I borrowed this word, so that's why I thought.
Even though multiple.
So many cases are pending.
No, I have an additional issue, Lords. Your Lords, the audit process has been conducted with the superintendent of Central Excise and GST, Lords. As per the CBIC notification, Lords, the superintendent, Lord, he is not authorized as per Rule 101, Lords.
Who is authorized?
Lord, the Assistant Commissioner, Lords. The Lordship would kindly.
Goes back to that Rule 34.
Manas. If your Lordship would kindly come, my Lord, to the rules before I take to your the Lordship to the CBIC notification. Rule 101, if your Lordship kindly. GST.
GST note. Yellow.
Your Lordship, Rule 101 limits. Lordship, will kindly straight away come to Rule 101 limit. Sub-rule 2, Your Lordship, and kindly see where it is, just place it here, where it is decided to undertake the audit of a registered person in accordance with the provisions of.
We are grappling with finding the rules.
Because Your Lordship, may kindly take.
We are grappling. The font size is too small to tax the eyes.
Audit.
Audit. Your Lordship, will come to sub-rule 2, my lords, where it is decided to undertake the audit of a registered person in accordance with the provisions of section 65. The proper officer shall issue a notice in Form GSP.
Who is the proper officer?
So that has been, for that note, I'll take a lordship's to the CBIC notification, which is
Section 2.
section 2, my lord.
Section 2 proper officer is defined.
It's defined. And that the CBIC, my lord, has authorized who will be the proper officer for 101, 2, 3,
Where
4,
is
and
that? Which
no,
page?
page 47, my lords. And issue 6. In exercise of powers, and issue 6 at page 47. Proper officer relating to provisions of other than registration and composition under the central.
This is under section 65.
Months. Months.
So it's the deputy or the assistant commissioner.
Months. If your lordship would kindly turn over the page.
No, I understood.
Months.
I'm just saying it is only deputy or the additional.
Months. And a similar power has not been given at all to the superintendent. The lordship would turn over the
And
page.
where is the superintendent?
No, sir, 49, page 49, lords.
The lordship.
The 101 is
Section 7 it is given.
65-7, my lord, is the communication.
Serial number 4.
My lord.
And 6 is?
My lord, 65-7, my lord.
It is, you say, communication. What
60
about 6? 65-6.
66-6, my lord.
66-6.
66 doesn't deal with audit, my lord. 65 is the audit provision.
I'm 65, I'm talking
My lord.
about.
My lord.
Please, superintendent,
My lord.
you will find subsection 7 of 65.
My lord.
I'm talking about what is this subsection 7. Because the deputy or
Seven,
assistant
Lord.
is given subsection 6.
7, my
This
lord,
is what a notable distinction.
where the audit is conducted under subsection 1 results in a detection of audit not paid or short paid or erroneously refunded or input tax credited wrongly availed or utilized. The proper officer may initiate action under section 73 or 74 or 74.
So it is the superintendent.
It is, my lord, he will not.
Subsection 7.
My lord, he will communicate, my lord. So far as, my lord, your lordship would appreciate. There's an initiation.
You show me. You are appearing every day. Let us see.
Your lordship will
I go
kindly.
by the
My lord,
section 65.
65-6, my lord, your lordship will kindly see. On conclusion, your lordship will kindly see.
That is the communication.
My lord.
Communication is under
Superintendent is given power under 7.
7.
What I'm saying.
So where the audit is conducted erroneously so and so, the proper officer may initiate. Because the superintendent may initiate a proceeding under 73 or 77.
Yes.
But so far as the initiation and the conduct of the audit is concerned, he has no role to play.
So after conclusion of
After conclusion of the audit process,
Then the audit will be done by any commissioner or any person authorized. Officer.
authorized.
So
And
he may be superintendent,
No,
he
no.
may be
Your lordship,
authorization.
your lordship may kindly say that turn to my lord, the sub-rule 3 of rule 101. Who will be conducting, my lord?
Proper officer.
Proper officer. And who is the proper? And the superintendent is not the proper officer under rule 103, my lord. 101 sub-rule 3, my lord. It's a assistant commissioner or the deputy commissioner.
You are challenging the audit to be conducted.
The audit was, I am challenging, my lord, that the audit was initiated by the authorized person, that is the assistant commissioner. Then the audit process continues and the final report is given.
Right.
The audit is initiated by the proper officer as per the provision.
That is what
But
I
the
was.
conduct of the audit, my lord, under the conduct of the audit, the examination, my lord, part of it is being done by the superintendent, which is not contemplated as per rule 101. That is, my lord, only the superintendent, only the deputy assistant or the deputy commissioner.
Sir can do.
My lord. Because that is precisely the powers given by the
So
CBA.
after conclusion only.
Only he will be initiating the process.
To sustain this.
Political institution.
Have you passed the subsequent circular? This is, he is relying on 5th July 2017.
My instructions are not.
Subsequent.
My instructions are they still hold the feet, subject to what my learned friend
Any
is.
subsequent proceeding this?
I have placed it.
The subsequent notification of or superintendent under chief
The subsequent one or principal.
and rule 1.3. Can you get it by Monday? Does that?
Yes.
So that is the
This
only
is
thing. Otherwise, that
Multiple layers there, ma'am.
will
Ma'am.
decide.
So this is an additional point in addition to this.
This is a unique point, we can segregate without tagging this matter to that. We will decide on this.
Monday.
This is only a question of.
Yes, yes.
It remains of Madras Cement now. We were grappling with that.
Can it come after the holidays or subject to your lordship, sir?
No, Monday, let him. Get the
Yes,
instruction whether.
Whether it's still holding the field or not.
That's keeping the point open, the multiple years. We can dispose of the requisition on the ground of jurisdiction, which means the competence. We can. So we're keeping that point open if it so arises in the another.
In fact, I have also taken that point of multiple years. This is an additional point in addition. But if I succeed in the second point, I need not go
On
to
that,
multiple
on
years.
that point of jurisdiction,
If I succeed, I need not go to the multiple years.
you know, heard this is the challenge, basic challenge. So get the notification if at all. Otherwise, prime facie, it seems that superintendent has authority. It is only after completion his role comes.
Yes, so that is.
Item note 13. Thirteen.
But the personal hearing may be different. Yes, then we should have notified for personal hearing.
Practice fix. When is it done? You're mixing on Monday, within 3 days.
Let them not take any precipitative action.
Please tell us the day.
Petition. I think that we have filed.
13th of October.
Mr. Asif knows
I'll just take an instruction. and-
how to get over this situation.
I have already implemented that file.
Where? Good.
Yes.
Huh? Good.
13th. Sir. Item note 13.
To cause arbitrary. 7340. Yes, next.
Item number 14.
May I please, Your Lordship? Item number 14, Your Lordship, is in absence of the GST tribunal. All the three matters, Your Lordship.
Give us.
Sorry, Your Lordship.
Yes, good. Anyhow, yes. 40.
Item number 15.
Oh, bless.
Please onward today. Please onward today.
After the petition. Without the name, which rules in this place now. So this is the matter of the 1 week after.
Item 16.
Petitioner in this case is a educational trust model. Is approved this honorable law. Witness the order passed by the Assistant Commissioner of Income Tax Exemption. That is page 59, so it's page 97, next step 15. The order passed under section 154 on dated 18/7/2025. Prior to this order, I have filed application under section 154 under annexure 13, and in annexure 14 they were giving a notice for hearing of the matter by fixing the date 21/7/2025. But passing the order on dated 18/7/2025. They are giving a
According to
personal.
you, keeping that application pending, they cannot proceed and pass this order.
Fine. Date is there, try to pass the order.
Why so hurry? The petition was intervening.
The petition is telling the assessment order. Passed on the
Assessment,
September
it doesn't- how we should pay-
Then the rectification order. However, the date was that is wrong. That was in hearing in 18 July 2025. Before that, there was only not back.
It says that he has already filed an application under section 154, seeking an exemption because of the educational institute of the trust.
Rectifying.
It's not a profiteering organization or profit-making organization.
Fine.
And therefore, if that being the position, suppose if it is allowed, then what will happen to this order? That is allowed. Yes. Do you not either continue disposing of both the proceeding if the same authority is competent, the same officer is competent, dispose of both together, or to decide that and then take.
This matter, you will remember, an opportunity will be given.
What about decide that?
As for provision of section 3, giving the rider to giving personal hearing to the party man.
Now this annexure 12,
Annexure 12 is assessment order.
no, this one. 97, annexure 15.
Annexure 15 is the order.
Is an order under 154, that is rectification.
Rectification.
That is passed on 18/7.
Well, notice is giving to us to attach
So
28/7/2025.
this rectification. Sir,
28/7/2025. Notice they are giving for hearing the matter on 28/7/2025. But
That's
the
not against the initial order. The initial order of
assessment
assessment.
in that is March.
I
How can you propose a date? Without rectification.
see annexure 11.
Yes, ma'am.
No, sorry, annexure 14,
Yes, ma'am.
page 95,
Yes, ma'am.
first line.
Yes. That was fixed on 28 July 2025.
Then next page. Page 97,
Yes, ma'am. Order advanced from 18.
order dated
18.
18. Can you pass through? That is what this question is.
I understood differently the way he placed.
But
But it is an apparent case.
answer.
It's an apparent case. The open and shut is not be there. No, have you intimated the preponed date?
No.
Never. Never. How can? That's a denial of the opportunity.
Well.
So. On the touchstone of the natural justice, it has to go.
Well, again. Yeah.
Natural justice. So late there.
Well, that's one opportunity may be given.
You will fix a date. I will intimate to him that when you fix the date, he will go and.
No course action.
Sir, if the order goes, then what course action?
You will be given the opportunity to have your say. Thereafter, he will pass 154 order.
Once you file 154, you cannot pursue the remand because their order is wrong as per.
So once it goes, that means 154 application becomes alive. Yes.
Item 17.
GST tribunal not functioning similar amount.
This for the.
Item number 18.
The meeting is regarding the non-constituent.
Item number 19.
Minor. But it's still multiple years. Apart from that, one substantive issue is there. Because audit was, departmental audit was conducted on 65, which is culminated in 73 proceeding and challenging the 73 proceeding. So I challenge here spending it for your lordship. Your lordship has already passed the interim order. In the meantime, CAG audit came and they verified the same set of accounts which was submitted before the departmental authority who conducted audit on 65. And they say due to departmental oversights, so they again propose for levy of tax on corporate guarantee, where there is no such incident in the state of Orissa, and they invoke the 74 proceeding. So they say the CAG says, so these are the departmental oversight, and the concerned proper officer they invoke 74 proceeding, and
So what is the wrong in it?
law is always.
What is the wrong in it? I just.
My lords,
If there are multiple, you say that there was an audit which was conducted under section 65.
my lords,
No difficulty.
my lords,
There is no fetter in the law that the CAG cannot do it after that audit.
absolute.
If they are empowered under the statute to do the further audit, it doesn't mean that they have to simply follow the mandate of the earlier audit.
I am not
They can
telling
take a
they are
departure.
conducting a audit.
They can take a departure, they can make an independent view.
They have taken the independent view, but
What is the wrong?
we are challenging the action of the proper officer for invoking 74 your lordship. So where is the intent of fraud here? Because
What you
when
wanted to say.
And
Yes,
both the audits, my lord, that are all are different on different subjects. The first audit for wrongful availment of ITC.
Then what was your departmental authority doing?
My lord,
Audit, they have conducted audit.
yes, my lord, but this was for a new taxable
New.
service. Taxable service, my lord.
Are they dehouse the record or within the record?
My lord,
The
this,
CAG found any material dehouse the record which was not disclosed.
my
The
lord,
authority is concerned.
my lord, this is
Then
absolutely different, my lord.
they are saying scrutiny of
When you are
balance.
doing an audit, are you doing an audit on a particular point? Even if you notice there is a glaring evasion of the tax, during that audit, will you only restrict to ITC?
No.
Or you will not go to the other aspect as well? If
No.
you are saying ITC, it was on a different, and it is on a different. It is the collation and examination and verification of the same document. What your department people were doing?
Lordship, the scope of 65 is
74.
73.
I can do, that is what, 74 element.
Prohibition. Is there any prohibition? To proceed with or to undertake.
No, my lord.
73 proceeding, any number of time.
No, that is no question.
It's a mechanical invocation
So
because
why-
73 limitation already expired.
Why 70?
Purely mechanical action.
It's compared with in your record.
My lord, these taxable service, my
As
lord.
your authority comes, prima facie or appears to.
My lord, this part was not, it is suppressed, my lord.
What
municipal
advice you received?
My lord, scope of 65 audit is to conduct the 360-degree verification of the books of accounts, which was verified. The only allegation
saying that it is only a 90-degree or 180-degree. He has not turned to 360.
Yes, your lordship, because whatever the allegations found in course of audit report on the conduct note 65, so that my friend is saying because the only allegation was in respect of ITC. So for other aspect was vividly examined and they said no tax is to be leviable.
That is why it will attract 74.
Not at all, your lordship. 73 they have invoked on those aspects.
They can do, there may be a escapement, there may be an overlook, there may be some bona fide mistake. But that does not mean that is what our view was quoting in 74.
My lordship.
If you do it under section 73, no difficulty.
74 is an exception.
If that
It's not a default route for
But if 73 is
73 already they have made. They have already made and yes, your lordship.
if doors are closed, then
But limitation already expired. So unless only the ingredient of 74 is there, that cannot be first and mechanical. Your lordship.
so according to them, it is really a back door which was open, we can count.
Not at all it's open, your lordship, because a mechanical action 74 is an
74 is
exceptional.
open.
It is exceptional unless until there is an element of fraud with an intent to evade tax. What is the intent of evading tax?
When I use the word back door, you did not understand what I mean.
Obliged.
if examination was subsequent and the returns were done by audit. And the CAG is has any material which was not placed before the audit, then only we will say that there is some suppression of that was audit was conducted without his disclosure.
They are seeking scrutiny of balance sheet. They are staying scrutiny of balance sheet, which has already been submitted by
Then you may say
the
it is
taxpayer
fraud or
before the audit.
suppression of material fact or whatever. If that is not there, is it your case? But that was not before the audit.
It is my case, my lord. It is my lord. Because my lord, here my lord,
That
this
law was
service
not
relates
that-
to my lord giving a corporate guarantee to other companies. That coming,
Was that document not placed? Was it not shown in the profit and loss account? Was it
Balance
not
sheet.
shown in the balance sheet? Was it not shown in the ledger? Was it not shown in any other document which is maintained in a commercial?
Yes, 45 euros.
Was it not?
Para
Because
2.1.
once you talk about a fraud, that what is the definition of a fraud? It's an act of deceit in order to have some gain.
yes, ma'am.
In a very truncated manner, one can. So there is a element of an intention. Has he supplied for his? Has he not disclosed to the first audit? Two,
My lord, as apparent from this record only, my lord, he has not.
that may be a bona fide overlooked by the audit conducted by the proper officer. This is for, he has not indicated that. But does this act, there may be an evasion, does it act tantamount to a fraudulent act?
No, my lord, it is not a fraud. It
Then
is
74.
suppression.
Then
Suppression.
how 74?
Even suppression.
Suppression is a fraudulent, that's why I say act of deceit
With an intent to evade
with
tax.
an intent
My lord.
to gain. Evasion of tax is a gain to them.
This corporate
And,
guarantee, we are giving a guarantee against the loan provided by our subsidiary companies. So,
Loan provided to the subsidiary company. Provided
we have
by
not
the-
given loan, your lordship. They have provided.
that you stood as a corporate guarantor
Yes.
for repayment of that particular loan
Yes.
borrowed by your subsidiary company.
And there is no such consideration received against that. Unless until there is an element of
This
consideration.
is different.
Well, that is there.
In fact, the second audit, this CAG audit, it concentrates on this service, this copy.
Yeah.
That is what I'm asking, that was it that figure or whatever you have announced, that was
Was it that
never,
was not
that was
available?
never disclosed by him in his books of accounts or his audited balance sheet and profit and loss. But that figure was not emanating.
These figures are available before the 65 audit or not, that is just very much.
Not only that, from his books of CAG, what CAG has seen, his books of accounts only.
Yes.
So was that books of account not before the audit under section 65? This is the question we are posing. If that is not so, well, then any number of 73 is not prohibited.
Any number of 7.
Then 74, why 74? We have said under different context, no construction or whatever.
We have position to answer this.
Yes.
Let him ponder over to then come.
Yes. 74 invocation of jurisdiction towards invoking 74 as well as multiple periods. And also the action of the CAG, because they are the non-statutory authority. They are not, they have acted at the dictate of
Be
the.
satisfied.
Madam?
If reports and be satisfied
madam.
and tell us.
And otherwise also it is an applicable order also, that my lord just
Within the period of limitation.
yes, my lord.
So
Period of limitation is there.
within the period of limitation.
Condonable period of limitation is there, my lord.
I think by now one or two honorable high courts have already delved into the merits or demerits of section 74 jurisdictional aspect. You have not come with us.
I have not gone through, my lord.
You must have come.
Complete instruction come on Monday.
My lord.
You know, or we will sustain.
Item note 20.
Please, my lord.
कागज आना.
The only humble prayer of the petitioner is that his first topic hearing is going on. The annex to 3, the conditional stay order granted by the commissioner to deposit 5 lakh on 8th December. So that may be protected by the no coercive action till the disposal of first topic. That is the
Without payment.
the high pitch assessment, my lord. The interest figure is 4 lakh and it is enhanced to 55 lakhs, my lord. Entire amount deposition treated as an unexplained source. And when it is a from business source. My lord.
If it is there, then what can be done?
Let the first appeal may be decided the matter within it is from August to it is going on first appeal.
Yes, dispose of the matter. First will dispose of.
Madam. Madam, petitioners, I filed two state petitions, madam, 2017-80 and 2020-21. So he has already been allowed the full stay for 2017-80 and he has been asked to pay only very substantial payment, 7% of the demand is 5 lakh rupees for the remaining stay for the 2020 and 21. And date was given on 10th December 2020.
So what happened on 10?
No, I learned they have been
That order I have challenged annex to 3 is to that order. I filed before that.
So where is give me a size the discretion, then what more?
My prayer is only that the appeal may be decided
Without payment.
That is a conditional, not
Without payment?
not a
Fair
pre-deposit.
enough, very good.
The appeal hearing notice, my lord. It's August is going on, my lord. First appeal hearing.
So what is the amount for 20%?
7%. They wanted 7%.
CBDT, I think 20%.
Yeah, 20%. But
But he has excised the discretion, he only got 7.
In not everything, but in big cases.
What more? He is more benevolent to you.
I don't know, I only query that let the appellate decision.
We are directing if you deposit within 2 months from the date of the deposit.
Right.
What did you do? Deposit?
The financial condition is not good, man, that may be considered to get in that position.
He gives you to appear.
No, already, Pat had an order already at the appellate authority before the appellate authority.
You did not understand what I said.
of returns. It is a covered
Yes,
matter.
Item 22.
73 4. 73 4.
Item 23.
Not by me.
It's okay.
Item number 24.
Item 24, limited grievance with accident. I have reported the entire tax amount within the time period. But because of the delayed filing of the SPA 02, that has been rejected.
128.
This order is applicable, Your Lordship. And in appeal, no pre-deposit is required. Only appeal is to be filed. This is a delayed application, Your Lordship. The notification has been issued by clarifying the dates because as after amendment of the statute, there is a clear cut. There is in the
Time is specified. Time is specified.
Your
On
Lordship.
deposit.
Your Lordship. No, not even for filing.
Filing.
Deposit as well as
So
filing.
she is within that time.
Not within time.
How much delay she has caused?
That is that to be filed by 31st/6/2005, 2025, and there is a delay of more than 2 months.
Okay. What is the outer limit? No outer limit.
Here it is.
Or there is any outer limit for preferring an appeal or condonation?
No, preferring an appeal, he can prefer.
No, this is waiver.
Condonation?
This is waiver.
Waiver. So waiver, this is not outer limit.
Waiver of interest and penalty.
Correct.
Withdraw the appeal, not to pursue appeal, but pay the tax in entirety.
She has already paid the tax.
Tax and
But
interest.
after.
No.
No, within time.
Before 20.
Within time, tax is paid, only she wants a waiver.
Tax and interest has been paid much earlier than this.
Your Lordship, the facts are
Only
confusing.
Entire tax you have deposited.
Entire tax and with interest.
When have you deposited?
That is at the Lordship, but pays. In appeal order, Your Lordship, that is 34, page 34. Only penalty is there.
Not deposited, that has been allowed.
Just down.
Page 34.
34. Yes.
That is the appeal order. In the demand order, there was 29 lakhs, some odd was there. And in appeal, Your Lordship, there has been.
Only 70,000 rupees is the penalty. Only. And what was the tax amount?
Enter allowed. Enter tax amount has been allowed. tax, interest, everything has been allowed by the first of
Page
the
31.
only penalty has been
Only
taxed.
penalty he retained,
Yes.
70,000.
Penalty for limited purpose, that penalty is.
The page 31, audit paragraph.
So she wants waiver of this 70,000.
So you have a turnover of several crores. 70,000 is a peanut for you. What are you doing?
And the
He has
demand was
recorded.
29 lakhs. The original demand was 29 lakhs.
Tax and interest has been paid, that is.
I understand.
Only this, only on the mail view will accept.
We better let him file appeal because appeal is there in the notification, clarification is there, no pre-deposit is required.
Oh.
Yes.
Mr.
In delay.
I am asking you one question you are avoiding to answer. Suppose if she goes and file an appeal, there is no question of any deposit, but she is already delayed. Now, is there an outer limit for condonation of delay?
No, condonation of delay question only 107. 107.
There is no outer limit. Even 1 year delay can be condoned by the appellate authority. I'm asking you, please ask him in a
Yeah, that's I can understand. I can understand. But
please ask him a vernacular language.
Is within limits. Within limit.
So he says that you go and file an appeal.
Already my application is there. Already my application is there.
Application for what?
Availing the waiver of interest on penalties.
Yes.
02 has been, they have admission, notice has been issued.
Why don't you waive the penalty?
That has been rejected. The application has been rejected. The rejection has been challenged.
Oh, take a pragmatic view.
No, you are please.
We are taking a pragmatic. We are taking a pragmatic.
Your Lordship, then
You say no, then we are taking a
Your Lordship, I'll take instruction and
No. She has paid the interest, she has paid the entire tax. What more?
Your Lordship, I have to take.
Have to be, there must be a humane approach. I understand.
Your Lordship, everybody will come. Everybody will come because this is the scenario. This is the only case.
Let them come.
So you are getting an interest, sir. You are getting an interest. It is not that they want for a waiver of the interest. You are getting an interest.
No interest.
She paid with interest.
No, not paid. Interest.
She said that she has paid the tax with interest. With interest.
Sir, if appellate authority has considered on merit and reduced the tax and interest to nil, then where is the question of penalty?
No, penalty is for other revenue para. Your Lordship, may kindly look.
So where is the tax demand then?
Tax demand for that default, tax demand is not necessary, Your Lordship. Your Lordship,
Your state is not run by penalties, sir.
Your Lordship,
Your state is not run by
that penalty is for non-filing. Your Lordship, may kindly page 33. Non-filing of annual return. That is a specific para, not for tax default.
So, in what way prejudice you to carry on with the assessment?
Power to waive penalty is there. Power to waive penalty is there in the provision.
If during the waiver scheme, they have got a limited periods.
Yes.
Section 128A.
Your Lordship, may admit, I'll let me file calm instruction.
No, we are doing it.
Because with great respect, Your Lordship, I could not understand the drafting, Your Lordship, because in some cases, only one annexure has been enclosed. Your Lordship, sorry to say, for that reason, I have to take instruction, Your Lordship. In the second case, Your Lordship, appeal, 2 assessments are there, 1 appeal order is there. So I could not understand, Your Lordship. I admit my incapacity.
This pertains to this period or outside the period?
1780.
1780. We are invoking C. We are invoking clause C. If you can't show your is there any amendment having brought in section 125? 125? No amendment. Same section stands. No difficult. We are refurbishing an order 1 rupee for GST and 1 rupee for CST. Because the word is may extend to 25,000, so it does not mean that it cannot be reduced. Maximum cap of 25,000 is given. It may be less. No difficulty. Yes, Mr. Mishra. What is the meaning of the word may extend to 25,000? Means outer cap of 25,000, beyond that it cannot, but less than it can be. So, see.
For the receipts. Also, the so-called notices are in delay.
Ma'am. 25 and 26.
27, 26.
Item 27.
You should oppose when he is appearing on the other side. Say no.
Says it is also school fee, but with an additional prayer that my bank accounts have been attached. So I have directed your lordship's order, but I have prayed not one more line that the bank attachment should be displayed. Otherwise, the lordship has given it time by order. And if I do operate my bank accounts, how do I also?
The Supreme Court has granted a interim order there. In those matters.
Those matters not
Because the apex court is in session of the matter.
Since no other high court
Has the apex court granted any interim order there?
Yes, interim order is there.
Interim order is there.
No other high court to dispose of similar matters since we are in season.
That is not an interim order, sir.
That's a restriction.
What are you talking? No coercive or something Supreme Court has passed. Then we'll have to record the reasons.
That's it.
We dictated the order yesterday that the reason is indispensable. One line will not do.
I was going to read you the bank attachment for if I don't operate now, that business comes to a standstill. I'm a works contractor.
The entire bank account is attached or to the certain amount.
Entire bank account.
How can you attach the entire bank account, sir? only to the extent of the amount which he is liable to pay. Look at it. If there is an issue, what is the report?
The Central Revenue Chemical Laboratory, that is to be accepted, or the sample extracted unilaterally by the assessee and tested at a laboratory of his own choice, that will be accepted.
Which is a central laboratory or a state laboratory?
In state, it is CRCL is the central laboratory, my lord.
Which one?
Central Revenue Chemical Laboratory, that's CRCL.
And where they have they got tested?
NABL. NABL accredited laboratory. SK Mitra.
SK Mitra
and Sons from Kolkata is an NABL accredited laboratory whose test reports were accepted. The tribunal, till the tribunal, not everyone accepts it. But unfortunately, I don't think it's a substantial question of.
No, was what that report came prior or after your report?
It's prior. It's prior, but my lord, only question, only concern.
So now you have the pass under the central excise to ask for re-examination.
My lord, here, my lord, only question is, my lord, only concern is, my lord, that sample which has been tested at that private laboratory, that was.
Did you raise an objection when it was tender and taken?
My lord, they have their own, they have examined, so extracted the sample and examined in that laboratory, my lord. And so far as.
Probably you could not get it, but I am just thinking about one judgment of the Supreme Court that is probably a Thane Singh, which is really going in my mind, and I am putting a question. I think under the Customs and the Excise Act, there is a power for retesting.
Yes.
Provision is there.
Yes, my lord.
And there is a mechanism and the procedure provided for that. What is a mechanism and a procedure? Did you follow those procedure for retesting?
My humble reply is, my lord, that may not be required because, my lord.
May not be required. Can you act contrary to law?
My lord, because, my lord, that sample which is extracted unilaterally, that is for their business purpose, for their export purpose, my lord, not for the payment of tax, my lord. They have to satisfy their original buyer that this is the content or this is that is for that purpose. My humble submission. But for the payment of tax, my lord, and there is a circular also, if your lordship will see.
Sir, the intention or the transaction.
Where is the provision of the Customs Act? You are appearing for the Customs.
My lord.
Show us the Customs Act. Where is the provision for testing?
My lord, if your lordship will.
Please show us.
Page 11. Page 11.
I will not. Facts will go.
No, it is circular, my lord. Page 11 of the brief, my lord. It is there in page 11. Page 11 of this appeal memo, my lord. That circular has been printed there, my lord. A last paragraph A. Last paragraph A, my lord. May I place, my lord?
Fight it out. Page?
Page 11.
Yes.
3A. A is the important. When a consignment is entered for export of iron ore, fines or pellets, samples shall be drawn in presence of customs by following the procedure laid down by Bureau of Indian Standards for drawal of samples of iron ore, fines and iron ore pellet and sent for testing. So there is a prescription that it should be extracted in presence of the customs officer and the assessee. And that unilateral extraction by the assessee, that is to satisfy his customer, not for the satisfaction of the tax liability, madam.
For the tribunal, it was your appeal. It was your appeal
Yes, ma'am.
for the tribunal.
Yes, ma'am.
What was your ground?
Well, my ground is that it should not be accepted that unilaterally extracted sample which has been examined at a laboratory of his own choice, that should not be accepted.
Where is that?
Your Lordship, kindly see page 20, page 26, internal page 8. No, I'm sorry, madam. Please. There is a, at page 21, if your Lordship see, para 3.1. My contention, para 3.1, running page 21, internal page 3, para 3.1. The contention of the revenue is that Learned Commissioner of Appeals at no point of time has negated test report of CRCL Kolkata and not submitted evidence information to prove that the test report submitted by CRCL Kolkata is erroneous and cannot be accepted. And para 4 also, my lord, the authorized representative appearing on behalf of revenue submit that for the purpose of export duty calculation, CRCL report should be prevailed. Accordingly, he submitted that Learned Commissioner of Appeals are in rejecting the CRCL.
What you have said. He has not discarded. He has given a reason that why the report of the CRCL is not accepted. Now it is a uniform decision taken by the Supreme Court in Gangadhar also, and our High Court has also taken it. that it is not the dry metric ton, but it is a wet metric ton. We should be no, that is the important part, sir. Your sample was drawn after a long period of time, and it says that the moisture is amenable to be evaporated by a natural process. And you have also said that the content is on a DMT basis. The tribunal has considered that this report really talks about a DMT basis, which is contrary to the judgment of the Supreme Court.
My lord,
Because by passage of time, the evaporation has taken place.
your lordship may kindly see, my lord, page 7.2. Here, my lord.
Whatever you have said, this is what it is not that they have not taken into account because they relied upon this report, they did not rely upon this report. There is a reason which is provided that why I am not relying on CRCL.
Your lordship may kindly see this.
No, the brother, this is,
Your lordship may kindly see.
and we have also taken it's a weight metric ton. WMT.
Weight metric
We
ton.
can't.
My lord,
We can't.
lordship may kindly see, it is not extracted at a billet.
By the time you have taken the extract which you have taken, sample, which you have taken, that is DMT.
No, my lord. That is immediately it has been extracted and packed, but testing is done after 39 days. So testing is done, my lord. What I got the instruction, my lord. It is very strongly packed, my lord. You put 3 to 4 layers in a tin.
No, sir. It is a fact finding. No.
If your lordship may kindly see for a moment. For a moment, 7.2. 7.2 paragraph. 7.2 only. Thereafter, I will not utter a single word, my lord. In the present case, we observe that the goods are exported in moist form, whereas the report of the CRCL Kolkata is apparently from the dry form. My lord, apparently there is no. It is an assumption, my lord. Apparently on the. My lord, this is my submission. My lord, it is apparently, and my instruction. I have taken instruction that it is wrapped 3 to 4 times. It is wrapped with a strong bottle tin container. And there is no chance of any evaporation. And it is not a case that it is extracted later in a delayed stage. It is extracted immediately, but tested after 39 days, 33 or 39. That is the case, man. That is the only point, man.
No, that is no point at all. There is no point at all.
Whether a unilaterally extracted sample.
It is not that. Sir, you are trying to divert the core issue. Your issue was not that. Unilateral or a bilateral. The issue was that what should be the FE content? It should be on a WMT or a DMT. And you have taken out a sample after 39 days of the materials being there. So this is a fact finding.
39 days after testing was conducted. Sample was extracted. If your lordship will see my.
Maybe you have sent to the laboratory after 39 days.
No, my lord.
There is a gap of 39 days. What is then the finding is very clear. What is the meaning of these words? I do not know.
8.1 is the.
Sorry, it says so.
If your lordship will see 8.1.
8.1 is there.
Yes, ma'am.
The sample of the shipping bill, the sample analysis of the shipping bill of 3.3. We observe there is a substantial delay of 39 days while testing the sample from the date of the collection.
The date of collection of this sample.
Sir, that is what I am saying. If it is kept, the sample is kept how?
My lord, it is thoroughly packed, my lord.
Thoroughly packed. We observe that the FE content is this. We do not. These are fact-finding authorities. We can't say it is wrong. If a fact is there, it's not a substantial question of law. It is only on a substantial question of law.
My endeavor was to impress your lordship that this unilateral extraction of sample and sense of.
When the DMT or WMT has already been decided, that's settled, there cannot be any dispute. And if the authorities have said report is done on a DMT basis, not on a WMT basis, because of the delay, evaporation has taken place. We do not find any
Apparently,
we are saying manifestly. Another word. No, brother. It does not involve a substantial portion. Where is the testing provision? Under the Customs Act?
This is the valuation works in fact, Melody. I think there is more.
No, there is, I believe. There must be, because that was the case. Anyhow, what to do with this case? That's the only thing. Yes.
It is 17 2, my lord, you will have to see testing relating to testing.
7.
The assessment of duty heading is the assessment of duty. After an importer has entered any imported goods under section 46 or an exporter has entered any
17.
17. 17. 2 is the testing. After such examination and testing, the
Of which act?
Customs statement.
I do not find this. This is 17 is the assessment of duty.
Assessment of duty.
Correct. After importer was the word which you are using, I am not getting that word.
Of 2, my lord. Subsection 2, sir.
Subsection says the proper officer may verify the entries.
This is the new.
This is the proper one.
My lord, I am sorry.
That's why I am surprised at what he is reading.
Consideration.
There is 4, my lord.
In a matter relating to tardy minerals, My Lord, Justice Raman was a party to it. They have dealt with how this testing procedures have been done, my Lord. And they refer to Rule 56 of the Central Excise Rules, which empowers the. Paragraph 7. Paragraph 7, if the Lordship would appreciate, their Lordships have extracted the circular and then the Lordship would turn over the pages. And paragraph 14, if the Lordship would through. The legal position with regard to acceptance of report, application thereof, and their Lordship the quoted paragraph 13. Under Rule 56 of the Central Excise Rules, the Central Excise Officer is empowered to take samples for the purpose of testing the samples. He has to communicate the result of such test to the manufacturer. If the manufacturer is aggrieved by the result of the test, he can request the assistant collector that the samples be retested. The procedure has been followed. Therefore, there is no procedural infirmity.
So it is a Rule 56.
Rule 56 of the
Central
Central Film. That's what their Lordship have quoted. So for this substantial question of law, my Lord, the Lordship have already held, my Lord, what is a substantial question? In this Jamon team.
That part that I cannot dispute, my lord. That is there.
Whether this particular dispute with of a report
is
is
wet.
then
Only, my lord, when I am trying to impress your lordship that unilateral extraction and impediment. That is the only point, my lord. Because, my lord, anybody will extract.
No, you
On
are,
his own?
you are not denuded. The authorities have not said that you cannot do it. The question was that when the two test reports are before the authority, then the which report the authority should say that it is a reliable one.
Exactly.
The finding has been made on factual basis. That why I am not relying on CRCL report. And you cannot say is perverse. It is unilateral. This is bilateral. So whatever be the result, bilateral will prevail. No law. Your contention is that the bilateral should prevail.
My lord, the sanctity of that report has not been also.
Not required. That's essentially a question of fact. Essentially a question of fact. Cannot be done. This is what our judgment feeling. Yes. Yes, call the next man.
Item 29.
Keep it for orders. Don't keep it. I know this will take time. Keep it for orders. Whatever he will give. No, stop to. It's 29.
Item 29.
Notification development has taken time. We ascertain whether this collector's objection was the collector's objections was filed within the objection was filed within the scheduled time or not? Because my learned friend was complaining.
Oh, this is relating to what?
Out still liquors of well, the Gram Panchayat had made objection.
Actually, I got confused because of his appearance. So.
I'm sorry.
No.
You are also leading something.
I do not know.
Uh-huh.
He has switched over to IMFL, so that's why.
No, not so. He has been.
Worse out still. IMFL is
Initial phase.
Yes.
Here I have obtained instruction. So Lordship may kindly see. The objection was made within time. But the date, as they say, that the copy of the notice was served on 31st. That was not 31st, it is on 24th. Or after 24, till next, in between next 24, they submit, a resolution was passed and that was communicated to the authorities. Basing on that, the inquiry was conducted and it was decided to sift the stock. The inquiry report was with respect to sifting of the stock because of the objection. Then since he was the opposite party was a licensee, private opposite party was a licensee for the year 25-26, unless his license is renewed, he cannot be shifted. So his license was renewed and subsequently he has been informed to shift the shop, which I think in fact redress the grievance made by the petitioner. If your lordship may
If
kindly,
it goes out from our area, we are happy news.
your lordship may kindly see the instruction.
Has he gone out?
Not gone. But that is the problem.
So
But the for shifting it was directed on 3/5/2025, the month of May. He was
true, but now has he shifted now? Have you identified the new place?
new place. She has to identify. She or he, whoever is the shop owner, he has the licensee has to identify and give it to the authorities so that can be.
So where is the licensee?
Licensee, no notice has been issued. Last occasion I
No,
pointed
then
out.
issue a notice. Let him come and then issue notice. 2 weeks on the license.
Notice by speed post.
Whatever. 3 weeks.
My lord. Item note 30.
OP5 is the license.
OP5. Thank you.
That in this matter, we are filing counter affidavit in course of the day. I will serve a copy to my lord senior minute.
They're not recording this subject.
No, my lord, counter is required in this matter.
We occurrence are taking time.
Counter is required for him. How can you prevent him?
Counter is required. I will
So
serve a copy.
counter 1 week.
Protection receipts from they can operate the bank accounts through that independently that will be.
Lord, this is relating to whether deletion of name is permissible or it is transfer of license. This matter, my lord.
It is only deletion lordship. We will break deletion, no ship, license not transfer. The provision is not.
File your, and we are keeping this on Tuesday.
My lord. Okay.
This Tuesday, 23rd.
Yes, ma'am.
Oh, no, reopening.
5th January.
Yes, reopening.
Item 31.
It just escaped from my notice. Yes.
31.
Even the case law when my learned friend was to take instructions regarding acceptance of the delay in filing of this audit report, because the auditors were not available for the state, were not.
Yes, they say that you find out your auditors or something.
And that
Yes.
is the time.
Yes, they were not at fault. No.
I have not yet instruction. I have not yet obtained instruction.
Then we are deciding this. What can be done? If they sat over it, how long they will continue suffer the sufferance? How long they will continue sufferance?
High Court law, they.
Is it a purposeful that they are not giving for some reason or?
No. We had a purposeful.
Why they are not giving our instructions? That is what I'm asking.
Their own chief commissioner approves that these are the reasons for the delay and he sends a report. All the same will.
Last occasion we have seen. That's why we asked.
The Bombay High Court has said no, they should not take a pedantic approach to this. Where the state authorities are to audit a cooperative society. So it all depends on the time the state authorities take to complete the audit report. And here is a typical case where they say that we are running short of statutory auditor. We have a panel, you select from the panel, take his consent, give it to us, and with the condition that he can't do it for 2 consecutive years. So all these restrictions were the causes of the delay, which was noticed by the principal commissioner as per their own circular. It was sent to the authorities, and still, Lord, he says that this is purposeful and I'll reject your application. Not sure.
No reason.
Bombay High Court, the Lordship can be. Page 6 if you'll kindly see. Paragraph 8. Here's also the question of dealing.
Allow that. Do it. Adopt the approach of a Bombay. For orders.
Also refer to the additional affidavit which I filed. Contains the report. I filed the additional affidavit there on this one. That contains the CBDT circular as well as the report of the commission.
What is that?
I should have.
Yes.
32.
This relates to an assessment against a dead person.
Oh,
And
you are for?
I'm for the department.
Yes.
I've gone through there is a specific provision to assess the legal heirs in the finance area.
So, how can you assess against the dead person?
Sub-item 2, you're also appearing for the petition. In sub-item 2, I'm appearing for the petition.
Same, dead person.
Yes.
But in item number 2, you have already filed a functional lawsuit for this. Sub-item 2.
That you can do it against the dead person. So,
We came to know only after recovery notice was served to them and they informed us in 2024. The order was passed in 2023 or lawsuit.
Then.
so why you did
this thing lawsuit?
so why you did not rectify, because before passing of the order they already
So
intimated?
when the recovery notice was after order was passed in 2023 or lawsuit.
Yes, and he
Then recovery notice was sent to bank attachment. Then they inform us in 2024 that
I understand 22 they informed.
no.
But your lordship, the person was already dead before they initiated the proceeding.
We were not aware, lordship.
So what does it mean?
Beginning of the proceeding.
Then what does it mean? Under what provision you can save yourself?
We can say alternate remedies available.
It has already been
Who will file?
Legal.
Who will file?
so far, central excise and
Who will file?
Legal.
lying on this.
And how they will get a Vagalatama?
the Honorable Supreme Court says, there's no provision for this proceeding against the legal heirs so far as central excise is concerned. The Finance Act is similarly placed. So the legal heirs also cannot be proceeded against. Unlike the Income Tax Act, they have considered the Income Tax Act, and even in the GST Act, they have said this.
This is under Income Tax Act.
Finance Act. Service Tax, Finance Act.
So what more? It has to go. Which paragraph?
Para
Of Sabina judgment?
para 31 is the most important here. Para 1 says the proposition.
It is. And 31 to 31.
May I read your?
No, that was in case of a customs. Central excise.
Yes.
This judgment relates to Central Excise and Salt Tax. However, here the Service Tax Act, which is under the Finance Act, is also similarly.
Are absent here also.
Yes.
Except the Income Tax Act and the present GST,
Yes.
there's no such.
Income Tax Act is there.
It's there, because there the lordships have said that you are inheriting an estate. So once you're inheriting the estate of the deceased, you are liable to pay. That is
also refer para.
Here, the taxable person is not there.
Yes.
Plus
Plus, there is no provision where you can enforce that.
And the money which you paid while exporting or importing, what has happened? You have not appropriated. You have not inherited as an asset. under the central excise, what it says is excise duty on the goods.
Para 1.
On the goods.
Yes.
Excise duty on the goods. Goods have been appropriated or inherited by you.
Yes, the
So,
processing was para 1, your orders.
Paragraph 10, they have discussed about the Income Tax Act. Vis-a-vis the central excise.
what is the factual aspect here?
Actual aspect, not the
The
petition.
dead person, what he did,
No, he was,
what he used to do.
he was running a guest house in his hotel till the corona period. He suffered from corona and he died.
He was running a guest house.
He was running a guest house. A part of his house was let out as a guest house.
Now you are letting out.
No, we are not. We are not. And if at all we are letting out, Lord, we are.
That's a Airbnb.
No, but we can't inherit that particular.
You have inherited the house.
No, we have inherited the house, but the tax is on the service, Lord, not on the house. With great respect, Lord.
I know, but
But the facilities which we are enjoying, in case your lordship are correct, that we are the liable, Lord, when we are letting out that houses. Not for what my father did or my predecessor did.
he was running a Airbnb.
That concept was not there in 2021 with ownership, but it was something like a fixed cost. So something like a paid guest.
Paying guest.
Paying guest facility. There, the lordship have said that whether this can be levied without a statutory provision. The paragraph my right, the learned friend is correct.
No, I am looking at the perspective of the fact. Because that case started where the father or a person who was running a proprietorship concern of rubber treating. And it appears that he stopped manufacturing or whatever the activity is there.
Question which
And then the imposition was done that you have done it secretly and you have not disclosed.
you have not the proposition.
Then the court was considering that they were not running that business, neither they inherited that business because it was closed by the father. And then the question arose whether there is anything which has passed down as an asset. The court says it never passed down as an asset.
In my case also,
It never passed down as an asset. Then in that event, whatever he has done during his lifetime, if the inheritance is not there, then in that event it is not liable in absence of any provisions of law.
There, the lordship would see my learned friend is correct in saying this appeal raises the question as to whether a dead person's property in the form of her estate can be taxed without.
That is what I am asking. That is what is a special feature that has come.
So, my lord, if the machinery provision is not there, Lord. The facts, your lordship, are correct. But now the lordships of the Honorable Supreme Court are considering that in absence of a machinery provision, unlike the Income Tax Act, can this particular levy be made against the debtor?
The question, the rider is that it does not form part of the state.
That is for the income tax law. That their lordship, the paragraph 10, they have discussed the Income Tax Act. That how this Income Tax Act has a provision.
Yes, how can you do it? It can't be done.
In the present case, there is no inheritance option. There is nothing which has been passed on.
In his case, is the father who was running that paying guest or something like that. But they are not running.
Regarding the inheritance that
We don't have inheritance tax.
That I have to check my lords whether
Inheritance.
Very interesting. Now, another is whether the liability, the tax is a liability.
the continuing business probably that might the business is being continued.
No, that's not the finding.
Yes. In absence of any job insertion. Both the cases.
Madam.
Call the next.
33.
Yes. What is?
So file an amendment.
File an amendment. What amendment?
That's enclosing, challenging the order which they have passed in the meantime. That have
Is the subsequent event.
First.
Oh. Amendment is to be allowed. If during the pendency of the writ petition something has happened, then obvious.
It is also revisable. Let him.
Maybe that we will consider after allowing the amendment. Can we allow the amendment and disallow the amendment? They can challenge it. Whether the court will entertain it or not is a different book. So we can allow.
Originally, they have filed the writ petition with a prayer to dispose of the representation. The direction to dispose of the representation. And pursuant to that, your lordship, during pendency, we have disposed of the representation and we have sanctioned the report. If at all he is agreed, so that is revisable. So what are my respectful submission? Let him file revision petition without filing.
That will be considered after the amendment is allowed.
As your lordship.
Brother, this is an application for amendment of the writ petition.
34.
Lordship, item 33, Lordship has already admitted and directed me to file counter the Lordship. So Lordship, I am waiting for the hearing. I mean, I pray your Lordship to extend for the previous time for filing of counter. Already interim order.
First extension or second?
First. Already interim order has been granted in favor of my Lordship.
First extension we grant 2 weeks, 1 week after reopening or 2 weeks after reopening. Interim order to continue till the end of January 2026 or until further order, whichever is earlier.
Item 35.
So the listing will not deter. Yes, sir.
Last date for instruction. Yes, they have not. And so the second so cause notice. Already matter has been finalized in the appeal. So after that, again, this will be self-service.
The second phase last one.
So the review order has been passed. So he has challenged the review order.
No. The review order.
So this was a resultant effect of a review order.
Review order. So that notice is no relevant as on date because after order is passed.
Provision
Of the review order.
Review. The power.
I'm asking, no, they have not challenged this order. They have to challenge this order 22.
They have issued the so cause notice. I have filed the reply and adjudication order was passed. Now on that basis, commission has directed to file the appeal. That is department of.
No, the appellate.
Appeal has been filed.
The appeal was filed.
Yes.
Appellate court disposed of on 7/8/2025.
Yes.
And this note and review order is passed on 20th of February 2025.
Oh, this review is to decide to file appeal.
To file appeal. That is on February 25.
You have commissioners.
See. Once the appeal is allowed or whatever, that is disposed of, what more?
The delay, why the delayed notice, that is in the first paragraph, the limitation period prescribed under section.
No, I'm really, I'm surprised to note this last paragraph. The show cause notice dated 25/9/2025 was issued by the Joint Commissioner, GST Central Excise for recovery of erroneous refund pursuant to the review of a refund sanction order by the Commissioner and the consequent issuance of the review order dated 20th February 2025. So it was, I do not know, first thing is that this show cause notice, the second show cause notice is on the basis of this order dated 20th of February 2025.
First notice, not second.
Okay. The second notice is
Certain confusion. 20th of date is for filing of the appeal.
Sir, take us to your date chart.
and then you say the said show cause notice is not issued in consequence to the order in appeal dated 7/8.
Yes.
Which was subsequent to the review order.
Yes. And then the first paragraph is
Administratively.
This be show cause be dependent upon that decision.
That cannot.
the date that has been issued, the reason has been previously it has been
Sir, if he has committed an error, let him admit that I have committed error.
yes.
But do not justify with a ground which is illogical.
Yes.
Apparently, if I correctly understood from my brother, that this review order means whether the department would go for an appeal or not. Can it be an order which may invite a show cause notice? It is you go in appeal, file an appeal. Show cause will be issued on that decision. Interesting. And once the original order is affirmed in an appeal subsequent to a review order,
Yes.
then tell me, how can it be?
Kindly have glance to my date chart, it will clarify everything. Sequence.
Serial number 4.
Then, that is the order.
Order issued in
Refund has been done.
refunded.
And second, serial number 5, Commissioner
Review order.
review order. An appeal has been filed by the department.
To challenge the
Appeal filed by the department.
Yes,
The matter is affirmed. That is on 7-8 order.
that is against them. That is the 7-8 order.
7-8 order means their appeal.
Their appeal has
Then what remains?
that is dismissed.
Then
Then they have to either go against the show cause after that.
how can you?
It is real. Late so simple. In the first para, they have clarified that why the delay has been there.
Can it be a issue which is now settled? Can you issue a show cause? Show cause for refund?
Are you in second appeal before the tribunal?
Not yet. Not yet, but it is going on.
Well, I'm just going wild.
Presently under
Whether they are in contemplation to file second appeal.
There is still a provision.
Then notwithstanding this. Notwithstanding this.
The time has not elapsed.
You know, but.
This show cause has to go. Because if there's one
Show cause cannot.
and have glance to 112 section. That is the appeal provision.
No, it has to go.
Let me live.
Yes. Yes. 36.
Item 36.
Thank you.
Item number 37. Yeah.
I said all the PILs should be listed. Why it is not listed on the PIL? We'll take.
After discussion.
Yes, after vacation. On the prayer of degrees.
The petition cannot be disposed of because the representation submitted by the petitioner is already inquired in and the report is also
And the allegation is found to be true.
no.
So,
It is also communicated to them.
oh,
I have to after discussion.
after vacation.
Item 38.
Give me 5.
Maths.
Yes,
On the petition, communicated on the petition. The opposite part number 3.
huh?
On petition is filed by the petitioner to opposite party number 3 under annexure 1
For what?
for eviction of the public fund and public land by the encroachers.
We have already said that they have also taken a policy, no tolerance so far as the encroachment is concerned on a public government property. So there is no difficulty. They will initiate under OPLE Act.
Here is a question. That's it. Kindly come to page 13.
1-3.
Yes, the petitioner is convicted. Now he is
Petitioner is
convicted.
He is in different cases in jail custody.
And he is in custody. From the custody, he has written a prisoner's petition to the Tahsildar. As well.
Where is the difficulty?
Now, as for Mr. Jail manual, the prisoner's petition can be written for particular purpose.
Huh?
As for Odisha's model jail manual, prisoner's petition can be written for a particular purpose.
Not for this purpose.
Not for this purpose.
To us. So keeping this matter 1 week after, you come ready.
In the mean period, I'll find it.
No mean period.
Item
Person of them.
39.
Yes.
The humans is minor, the villagers of Kendupatna,
Street electric and light supply in the periphery of this. So this is a municipality?
No, it's not a municipality, this is community.
No, 39 is a Ritukanto Bastia.
Yes.
Which matter you are?
Yes.
Yes, 30. Yes.
So your prayer is should not be given to appropriate such and such to take effective steps to provide street electric or the light supply in the periphery of such and such. This is your prayer.
Yes.
Now, who will supply? Is this municipality or the corporation, municipal corporation or what?
In fact, it has come within the zone of the extended BDA jurisdiction. Extended BDA jurisdiction, Bhubaneswar Development Authority jurisdiction, it has come.
So it should be a corporation or the development authority who will provide?
Authority also. Bhubaneswar Development Authority.
Why I'm saying that in other part of the state, in a big city, this poles and all, everything takes care of by the municipal corporation.
Here also in Cuttack also by the municipal corporation. And here I have taken instruction from my friend who was engaged. He says that this is within the zone of the extended Bhubaneswar Development Authority, but they are yet to have their entire domain, and they have made the reference to the ADM. So the ADM is now the authority who will take care of it, and that is how the reference has been made to the ADM. That is opposite part number 4.
This is a necessity. How can you not provide the street lights?
Miller, it is already in the process, Miller. The ADM has informed that ADM has already taken a decision 17/9/2025 and he has directed to the block development officer Bhubaneswar to take immediate step, Miller. Today I have talked to the block development officer. Now they are sanctioning the funds for the purpose, Miller.
Okay. So purpose is served.
Now, but I am praying for you, Lakshmi, only keep it to after vacation because it has taken them 3 months to implement. He said on 79 the decision was taken.
There are the procedural administrative hassles. You are quite aware.
I'm not complaining about that.
So you are quite aware. Now they have sanctioned. Now everything has been taken in principle. Now they will sanction the fund. Have you gone to the revenue department for sanction of the fund?
It is like the department or urban development.
There's no difficulty. So they will allot a fund for that and they will provide.
Your Lordship may take note of the submission of money.
True.
And make it, your Lordship may make it time bound so that whatever your Lordship needed, so that it can.
The petitioners are Yes.
And this restriction, the eviction of enclosure from the government land. Eviction of enclosure from the government land.
The petitioner has to file affidavit in proper format. So kindly come to page 22.
22.
20.
No, yes, I have to be very. What is this? What you have done? Don't go by the technicalities.
I will obtain instructions.
Don't go by the. You have to be careful, sir. The affidavit portion is not a casual exercise, sir. If it is proved that it is a false to your knowledge, it may invite a criminal action to be taken. So it's not so casual that you should do it. Anyhow, next.
Item 41.
2 weeks after the thing. So take instruction.
In this case, my lord, petitioner brings the enclosure.
What is, they have already taken a decision.
The enclosure, when the Tahsildar take a action and take a police force, immediately the enclosure file a suit. And in the suit, the trial court dismissed the interim application on 10/10/2025. Thereafter, the suit is pending. Then Tahsildar not evicted the.
Why don't you take instruction?
Court order also, this order also.
We have made an extensive, there is an order in one of the PIL so far as the encroachment is concerned. Now, there is no interim order. There is no interim order. Take instruction. 2 weeks after vacation. Yes.
42.
May I please, your lordship? Your Honor, the appellants before your lordship have challenged the issuing order dated 16/7/2025, passed by the Honorable Supreme Judge, holding therein that the petitioner number 1, being the second wife of the deceased employee, is not entitled to get the family pension and other service benefits. But admittedly, petitioner number 1 is the child born through the second wife of the deceased employee.
So he is entitled.
Yes, sir, she is entitled.
She.
Due to contention of the learned counsel for the state that wrong order has been passed, and that is para 5 of the input journal that you not see. Page 7, running page 7, para 5. Basing on the instruction, it is contended that the petition.
No, this is a family pension.
Yes, ma'am.
That's all. The family pension is not extended to
second wife.
Second wife.
But
if she is a second wife during the subsistence of the first wife or during the lifetime of the first wife.
Yes, sir. But admitted the petitioner number 1 is the daughter, not the wife.
So the daughter is entitled to a family pension.
Yes, ma'am. Daughter. Children born through the second wife are also entitled to get the family pension. That is the settled position of law.
Settled?
Yes, ma'am.
Yes.
That's on the line. Para 12 and 13.
Of
judgment of this honorable court.
This honorable court.
Yes, ma'am. Para 12 and 13.
Yes. Is a single bench judgment.
Mine, single bench judgment.
Not a settled law. Division bench can take a different view.
But
We are taking a different view.
This is a view
Ma'am,
where second wife is
not it,
not allowed.
not allowed, but children
But
want the
children-
second wife are in.
But recent Supreme Court judgment what it says.
So it's not a settled, as you say.
C Ramabai,
We are not taking.
C Ramabai.
No,
Uh,
I've not gone through it.
yes.
Check out, check out.
Well, that's next week. only.
Nothing is settled.
And you mean to say that
The applicant number one is the daughter of the deceased.
What do you want? You want a pension.
Pension.
Is it permissible to the child? And he is married or she is married? Family pension. So why how can you deprive the child?
No.
She is 20 years old. Child is at 20 years old.
Yes, ma'am.
So
Actually, what has happened is my love is in order. The Honorable Single Judge has proceeded on the premise
their second wife is claiming, but
actually-
not the child.
So that is the problem. Actually, it is a fact that the petitioner is a daughter of the second wife, not the second
so
wife.
why did the petition? Why did the appeal?
No.
No, my lord.
Denied, na? So she's a party to it. If the writ petition is dismissed, that means her claim is also impliedly dismissed.
That's my.
It's
We are allowing it, shows the provision.
No problem, my lord, is it is an error apparent because the Honorable Single Judge has relied upon the instruction provided, dated, it is written in the order, dated 19-3. So that is the instruction that the learned single judge just given. My lord. In the instruction, it is written clearly that the petitioner is the daughter of the second wife. Somehow, my lord, it has creeped into the order. Something wrong has stepped into the order. Error apparent.
Should we relegate back?
Yes, my lord, that would be more.
Huh?
Yes.
The writ petition filed by the disposed.
Okay.
What happened?
So here is the case where the applicant challenges the non-consideration of the case by the
Challenges the
by the order passed by the Senate, where the non-consideration of the case or demands of the present appellant before the which has been
what was the writ petition? You just first tell me the writ petition. What writ petition you filed?
challenging the notice for no confidence motion against fiction.
The challenging the notice of no confidence motion. On what ground?
The ground is no statutory within the notice has been served without giving opportunity of hearing the statutory period of 15 days. It's a
Does it require the opportunity of hearing before any notice is issued?
opportunity hearing that is
A notice of no confidence.
no confidence. 15 days.
So the rule provides that how many members has to sign resolution, everything is provided therein, and then the authority will have to call the.
Why I am saying that there is no consideration because of this matter. Initially, the meeting was held by the ward members of the Gram Panchayat. That has been decided. The question has to be made before the sub-collector. So no confusion against the sub.
True.
And that on 30th 6/25, the meeting was held by the ward member, and 4/7/25, requisition has been made before the sub-collector.
True.
Thereafter, the sub-collector issued the letter to the video to verify the signature according to the requisition or resolution.
You are talking about the absence of clear 15 days of margin between the post-delivery of such notice.
Yes, that is the number one. I am telling you before this, it's a foreground. Consideration of report regarding verification of the signatures made by the video and the violation of this notice provisions of section 24(2)(c) and the non-application of mine by the sub-collector, and third is legislative intent. Third matter is
So the notice was issued on 1st August and the date was fixed on 22nd August.
subsequent notice.
What?
Initially, notice has been issued. Notice was rejected on 19/7/25. The requisition dated 4/7/25 was rejected, and can see the date certificate. The said requisition 4/7/25 was rejected by the appellant 3 on the ground of the signature is not mismatched. The signature is mismatched. And subsequently, that was held on the 9th.
Another notice. This 1/8/2025 was issued.
Yes.
When have you received?
I have received as government has encountered 13th of.
When have you received?
The court has disbelieved it. You could not produce any document that 13th you have received.
Because of the government in his counter has admitted that 13th of.
Sir, you wanted that dismissal now or wanted to enjoy the vacation?
And here is the case. I am not understanding the soluble court.
Sir, we have also delivered a judgment in this regard.
So lack of struggling is say.
Yes.
This was for the lack of the full matters. I think it's a point of clause.
That is what is 24(2)(c) says that the clear 15 days, there is nothing. He has not said that a resolution or something like that.
His case 24/4 we have touched. 24/2/6 no.
We have decided in your case.
Let's see, but now the judgment.
Understood. That's a larger way.
24(2)(c) is mandatory detention. Honorable single just.
There the issue was the requisition as well as the resolution. Both have to be sent along with the notice. It is not the issue here. That's why I'm not troubling you.
No, but that's it.
That is not the issue in larger bench question has no application to his case.
24(2)(c) includes 15 days. So that will be held. That's by honorable.
Yes.
But larger bench was to consider whether requisition and
Initiation both are mandatory.
Both are to be served.
What has been held by the
Yes, yes. Help lordship. 21 as a whole is mandatory, that is standard.
that is who disputes.
Includes 15 days also.
Oh.
That is there.
And clear decision of this court is also. Maybe.
That is law.
Maybe. But 15 days we have to see what.
My parents can satisfy with the 15 days.
In that depends on fact to fact.
Fact.
On a particular.
Para 4.4 lordship and Roman 1 and 4. That
You are opposing this.
No. I'm not, just not assisting lordship. 4.4. My lord is reading that larger judgment 4.4. Roman 1 and 4. That is.
No, your argument is accepted in larger way.
Now has been laid down lordship.
When the question has been read in truth advice, after rejection of the signature, the requisition, just after 2 days, again.
Is there any prohibition?
No, but that's what legislative it's an intention to.
Sir, prohibition of the statute.
But the minute we should. Legislative.
See, no, that is a different. I see the reasons.
Once the widow has reported the signature of listener.
That you can, that it, the modified which is mandatory.
This case, for 4.41, it's capable.
Come after vacation. Clear out. Okay.
Yes, with the Lord's permission, may I make mention? Item 55 and 56.
There is the possibility. Can it go after vacation? Unless, can it go after vacation? Tell me. Will it perish before the vacation?
Yes, Maharaj.
If we take up the matter and do not find that it is so urgent, it can go after vacation. We will dismiss on that ground without a merit.
Maharaj, yes, Maharaj.
Correct? Are you taking that chance?
Well, let it come Monday.
No, please.